So arrest under CRPC. So today, the main topics which I'm going to deal today is who all can arrest, or how is arrest made, and what are the procedures to conduct an arrest, and what are the powers of the person who is conducting an arrest, and what are the restrictions upon such powers of such persons who are arresting. And at last, we will deal with the rights of the arrested persons and important case laws. So first of all, as I have told you before, arrest under CRPC, it is dealt under Chapter 5 from sections 441 to 60A. And as we all know, arrest is not defined under CRPC, but we can define arrest as deprivation of a person of his personal liberty, which is done under some legal authority, or at least by an apparent legal authority. So arrest means deprivation of a liberty of a person by some legal authority, under certain legal authority. So there are two types of arrest. Arrest may be conducted either with warrant or without warrant. And arrest may be conducted by any police officer or by magistrate or even by private citizens. So arrest can be conducted either by magistrate or by the police officer or even by private citizens. So as we all know, Section 41 to 44 deals with the arrest conducted by the authorized party without warrant. So arrest conducted by the person without warrant. Section 41 deals with the arrest by a police officer without a warrant. Then Section 42 deals with the arrest by any private person. And Section 44 deals with the arrest by a magistrate. So going in detail, Section 41. As I said earlier, Section 41 deals with arrest by a police officer, that itself without a warrant. So any police officer without any warrant or without any order from the magistrate can arrest a person upon certain conditions. The first one is if the officer felt that he has conducted certain cognizable offenses, or if there is any reasonable complaint made against such person conducting a offense, or if there is any credible information against such party, or if there is any reasonable suspicion existing, that is about that party conducting any cognizable offense, or if the police officer finds that that party is in possession without any lawful excuse, which shall be the materials, or which shall be the materials from an housebreak, or which who has been proclaimed under the court, either by the state government or by the central government as an offender, or if under whose possession the police officer or the finds certain stolen property, or there is any reasonable suspicion that that person has committed any theft, or who obstructs the police officer while he is executing his duty, or who has escaped or attempted to escape from the lawful custody of the police officer, or who is reasonably suspected of being a deserter from any of the armed forces under the union, under the central government, or the next condition is who has been concerned or against whom there is a reasonable complaint has been made, or any credible information has been received, or if there is any reasonable suspicion exists as per he has committed a crime outside the territory of India, and it is punishable in India under any prescribed law or law related to extradition, or otherwise he is liable to be apprehended or detained in custody in India. Or another condition is who being he is a released convict and he commits any breach of any condition under his release, which is said according to subsection 5 of section 356, or for whose arrest any requisition, whether written or oral, has been received from another police station, provided that person to be arrested or detained for any offenses or any other causes which he have made under the jurisdiction of such a police station. So these are the conditions under which a police officer can arrest a person without warrant. Should I repeat the conditions, or can I go to next provision?
Next provision, Surya.
Okay. This is stated in section 41. Then going to section 41A, police officer shall issue a notice of appearance if the police officer issue a notice as per the appearance of that person before the police officer upon receiving any reasonable complaint, or upon any credible information, or upon any reasonable suspicion, and such person failed to comply with the terms of that notice, then also the court shall pass an order to arrest that person. That is stated in section 41A. And section 41B, it states the procedure of arrest and the duty of the police officer while making such an arrest. So the procedure stated under section 41B are as follows. That is, every police officer while making an arrest shall, first condition is that, shall bear an accurate or visible or clear identification of his name, which will facilitate easy identification. And the second condition is that he should prepare a memorandum of arrest, and this memorandum of arrest should be attested at least by one of the family member of the person arrested, and also another member who is a respectable member of that locality from where the person is arrested. And it should be countersigned by the person arrested also. So the first condition is according to 41B. All these conditions we can later on, when we go through the case laws, we can find that all these conditions are stated as guidelines by the Supreme Court under various case laws. That is DK Basu and all. And this 41B, it is later on added to CRPC in 2009 only. So after the case law DK Basu and all, those guidelines were provided by the Supreme Court, and later on it is being amended. This CRPC is amended, and this 41B, 41A, all these are included by 2009 only. So all these conditions we can see as the guidelines provided by SC in Supreme Court in DK Basu's case also. So the first one is the nameplate should be accurate, the visible and clear identification of the name of the police officer conducting the arrest. Then second one is that he should prepare the memorandum of arrest, and it should be signed by a witness, and that witness should be the family member of the person arrested, and another member who is a respectable member of the locality from where the person is arrested, and it should be countersigned by the person who is arrested. Then the third condition is that inform the person arrested, unless the memorandum is attested by the family member, that he has got every right to inform his relative or any friend named by him about the arrest. So if in case there is no family member present while the person is being arrested, then it is the duty of the police officer to inform the person arrested that he has got every right to inform his relative or any friend who should be informed about the arrest of that person. So these are the rights of the arrested person according to section 41B. Now moving to 41D. 41D states the right of the arrested person to meet an advocate of his choice during the interrogation. So according to section 41D, the person arrested has got every right to consult an advocate or any legal practitioner of his choice during the interrogation, even though it is not throughout the interrogation. Then also he can meet his advocate or legal practitioner. So these are the rights, 41C, 41D, all these are the rights provided under CRPC for any arrested person. And these rights were amended to CRPC after various case laws and the guidelines provided by our Supreme Court, which we will deal later on. Okay, then going to section 43. These are the above given other procedures that should be followed while a person is arrested without a warrant by police officer. Now going to, if suppose a person is arrested by a private person, what are the procedures to be followed? That is dealt under section 43. So if in case any private person is arresting a party without any warrant, when can a private person arrest a person without any warrant? The first condition is that who in his presence commits a non-bailable and cognizable offense. If the private person, if that citizen feels that the party has committed a non-bailable or cognizable offense, or this is the first condition, or the second condition is that if that party is if that person is a proclaimed offender, or without unnecessary delay shall make over a cause to be made over any person so arrested to a police officer. So under two conditions, a private person can arrest any citizen. That is, first condition is that if he, in his presence, if that party is committing any non-bailable and cognizable offense. That is the first condition. And the second condition is that if that person is a proclaimed offender. So under these two conditions, a private person can detain the person, and he should be handed over to the police officer without any further delay. Or in the absence of the police officer, he should take such person to be taken to the nearest police station. If in the absence of police officer in the premises, that person should take that person in the custody towards the any nearest police station. Then second condition is that if there is a reason to believe that such persons comes under the provision of section 41, then police officers shall rearrest that. So section 41 is, we already dealt with that. That is arrest of a person without warrant by police officer. So after this person is taken to the police station and the police officer finds that this person that offense shall come under section 41, then the police officer should rearrest that person. Or if there is reason to believe that he has committed a non-cognizable offense and he refuses on the demand of the police officer to give his name and detail or give a name of residence, with such officer has reason to believe to be false, he shall be dealt under provision of section 42. So section 42 deals with the arrest of a person providing a false name, or who refuses to provide name and address of his residence. So if the person who is in such a case, the person who is arrested is not giving his name and address, or if police officer feels that he has given the fake or false name and address, then according to section 42, the person can be arrested by the police officer. So section 43 deals with arrest of a person by a private person. Now moving to section 44. Section 44 deals with the arrest of a person by magistrate. So there are two conditions, and the first one is when any offense is committed in the presence of the magistrate, whether the magistrate may be executive or judicial, within his local jurisdiction. Within his jurisdiction, he may himself arrest or order any person authorized to arrest that person, and may thereupon, subject to the provisions contained as to bail, commit the offender to custody. So the first condition is that if the offense is committed in the presence of the magistrate, whether executive or the judicial, within his local jurisdiction, he may himself arrest or he may ask any authorized person to arrest such a person, and subject to the provisions of the bail, conditions of the bail, he may render him to the custody of the police officer. And any magistrate, whether judicial or executive, may at any time arrest or direct the arrest in his presence within his local jurisdiction of any person for whose arrest is competent at the time and circumstances to issue a warrant. So if the arrest is competent at the time and the circumstance and there is circumstance to issue an warrant, such a person can be ordered to be arrested by the magistrate according to section 44. Now going to section 45. Section 45 provides the protection to the members of the armed forces from arresting for anything done or purported to be done by him in discharge of his official duty, except only after attaining the consent from the central government. So, and a member of the armed force can only be arrested for any offense or for anything done while he is under official duty only after obtaining the consent from the central government. That is provided in section 45. Now these are the, we have dealt with the first question, that is who all can arrest a person. First one is police officer, next is private individual, next is magistrate. We have already dealt with that procedure. Now we are going to look how an arrest is made. How can an arrest be conducted? That is under section 46. 46 deals with the conditions or the procedures of arrest. So first one, in making an arrest, the police officer or any other person, we already stated that police officer, private person or magistrate can arrest. So any of these persons making the same shall actually touch and confine the body of the person to be arrested unless there be a submission to the custody by word or action. So unless there is a submission by word or action, the person making the arrest should touch the body of the person who has been arrested. That is the first condition. Then the second condition is that provided that were a woman is to be arrested, suppose the person to be arrested is a woman, under such circumstance, on the contrary, if she doesn't submit to the custody by orally or by action, then arrest shall be presumed, or unless the circumstance otherwise requires, or unless the police officer is a female, the police officer shall not touch the person of the woman for making the arrest. If she is submitting herself to the custody by orally or by action, then it is okay. Or else only the female police officer can touch the female arrested person in person for making the arrest. That is the second provision. Then the third one is that if such person forcibly resists the endeavor to arrest or attempts to evade the arrest, such police officer or other person may use all means necessary to effect the arrest, can use force or all other means to arrest that person, which is only necessary to arrest that person. So reasonable force can be applied to arrest that person if that person is making any attempt to evade the arrest. That is the third condition. Then going to the fourth one, nothing in the section gives a right to cause, as we have already said that force can be applied, reasonable force can be applied. And the next condition is that while applying such force, that death of that person who is not accused of an offense punishable with death or imprisonment for life shouldn't be happen. So while applying force, it should be reasonable, and the death of that person should not be caused unless that person is punishable with death punishment. The punishment for that person is death or imprisonment for life. So the force applied should be reasonable while he is evading the arrest. Then save in exceptional circumstances, no woman shall be arrested after the sunset and before sunrise. And were such exceptional circumstances, the woman police officer shall be making a written report obtaining the prior permission of the judicial magistrate of first class within whose local jurisdiction the offense is being committed or the arrest is to be made. So this once again is stated in D.K. Basu's case. That is, a woman cannot be arrested before sunrise and after sunset, and under exceptional circumstances the police officer should get a written order from the judicial magistrate, first class magistrate, whose local jurisdiction the offense has been committed or the arrest is to be made. So this is the next condition. So these are the condition stated in section 46 according to how the arrest can be made. I hope it is clear till now. Can I continue?
Yes.
Yeah. Now, section 47, search of place entered by person sought to be arrested. Suppose the person who has to be arrested has entered certain place which doesn't belong to his area, his residential area, or his home, or any other, his office, or any other place. In such a condition, how can, yes, okay, search of a place entered by such person. It is dealt in section 47. If any person acting under a warrant of arrest or any police officer having authority to arrest have reason to believe that the person to be arrested has entered into or is in within any place, any person residing in or being in charge of such place shall on demand of such person acting as aforesaid or such police officer allow his such free ingress thereto and afford all reasonable facilities for a search therein. That is, any person, if the police officer or any other person having a arrest warrant reasonably feels that the person to be arrested has entered the property, then he can ingress into that property with all the reasonable facilities for searching that place. That is the first condition. Then the second condition is that if the ingress to such place cannot be obtained, if in as per section subsection 1 we have already discussed, if the ingress cannot be obtained, then it shall be lawful in any case for the person acting under the warrant or for a police officer to enter such place and search therein, and in order to effect the entrance he can break open any outer or inner door or window of any house or place. So if in case, as we said earlier, the person there is a person, the authority, that is police officer or any person with the warrant cannot enter the premises, then he can break in the outer and the inner doors and windows and enter the property. That is the second one. And he can demand for searching the premises. Then the third one is that provided that in any such place or apartment in the actual occupancy, if there is a female who being the person to be not being the person to be arrested, who according to custom does not appear in public. Suppose if there is a female residing in that property, in that place, who is not supposed to be to appear in the public and who is not the person to be arrested, in such a case the police can demand that person to reasonably withdraw from that area and then break open to the apartment and enter the premise and do the search. And if any police officer or other person authorized to make an arrest may break open any outer or inner windows or doors of any house or place in order to liberate himself or any other person who have been legally entered the for the purpose of making the arrest is detained therein. Suppose the police officer or any other person who had entered legally is being detained in that place. In such case, also the police officer or the person authorized can break into the area for searching the place. And section 48 states that the police officer may, for the purpose of arresting any person without a warrant whom he is authorized to arrest, may pursue such person into any place in India. So for conducting the arrest, he can pursue that person to anywhere in India. That is, apart from the authority from the local jurisdiction, he can move on to any place in India, inside the territory of India, for pursuing the person to be arrested. Then section 49 states that the person arrested shall not be subjected to more restraint than it is necessary to prevent his escape. That is, only reasonable restrictions should be put upon the person who is arrested, which is necessary to prevent that person from escaping from the legal lawful custody. So that is stated in section 49. Now, going to section 50. Section 50 deals with person arrested to be informed. That is the right of the arrested person, which once again is being given in DK Basu's case. That is, the person who is arrested should be informed of the ground of arrest, and also if he has the right to bail, then that information also should be passed by the police officer. The officer conducting the arrest. That is, every police officer or other person arresting any person without warrant shall forthwith communicate to him the full particulars of the offence for which he has been arrested or the ground of his arrest, and whether the police officer arrests without warrant any person other than the person accused for a non-bailable offence, he shall inform the person arrested that he is entitled to be released on bail and that he may arrange the sureties and on his behalf. So both the ground of arrest and the right to bail, both these rights should be informed by the police officer arrested to the party arrested. So once again, these are the section 50 once again is the right of the arrested person. Now going to section 50A, that is obligation of person making the arrest to inform about the arrest etc. to a nominated person. That is informing the arrest, grounds of arrest, the person arrested, the reason for arrest, the place of arrest, time of arrest, etc. to either to the family, to a friend or kith or kin. The information of the arrest should be passed. So this is dealt under section 50A. Once again, this is guideline given by the Supreme Court in Kuttipuram. So every police officer or other person making any arrest under this court shall forgive the information regarding such arrest and place of arrest or the person being held, detained or held to any friends, any of his friends, relatives or such other person as may be disclosed as nominee by the arrested person for the purpose of giving such information. So the information of the arrest, the place of arrest, time of arrest, the reason for arrest, all these should be, that is ground of arrest, all these should be given to, should be informed to either the friend or the relative or any such other person to whom the arrested person has nominated for disclosing the grounds of arrest or disclosing the information of arrest. And the police officer shall inform the arrested person of his rights under subsection 1 as soon as he is brought into the police. Suppose this person is arrested not from his locality, so then there may not be any family or friend to be informed. So in such a case, after bringing that arrested person to the police station, it is the duty of the police to inform such person about his right. That is, he has got the right to inform his family or friends or any other person as he wished regarding the information regarding his arrest. So it is the duty of the police officer. And then after that, an entry of the facts as to whom has been informed of the arrest of such person shall be made in a book to be kept in the police station in such form as may be prescribed by the state government. Once again, this is also guideline given in Kuttipuram. A diary should be kept in the police station, and on which all these details, the person arrested and the information of his arrest should be provided, and the place of arrest, everything should be recorded. So the format of that diary will be prescribed by on behalf of the state government, and it shall be the duty of the magistrate before whom such arrested person is produced to satisfy that requirements of subsection 2, and that is the police have already informed. It is the duty of the magistrate to check whether the police have already informed, has done according to the provisions of section 50A.
Different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional